Hi and welcome to Read With Me series on the Land Registration Act, Laws of Kenya. And today we'll start off with section 13 from where we left off on qualifications for appointment of Chief Land Registrar. Now we say that this office is a public office and the person who normally does the appointment is the Public Service Commission, okay? And the commission will appoint the registrar and require them to have the following qualifications. They must be a citizen of Kenya, must hold a degree from a university in Kenya, must be an advocate of the High Court of Kenya, must have at least 10 years experience in land administration and management, must meet the requirements of Chapter 6 of the Constitution. We said Chapter 6 was about leadership and integrity. So everything to do with principles under Article 10 of the Constitution should happen, should the person should have them. They must be, they must possess integrity. They must have good leadership skills. They must not have committed any crimes, not have been convicted before of any crimes, and so on. So a person shall not be qualified for appointment in the case he has been convicted. This makes sense. Is an undischarged bankrupt, okay? Has not met his or her legal obligations in relation to tax, has benefited or facilitated unlawful allocation or acquisition of land, has been removed from office for contravening the provisions of the Constitution. Now, moving on to Section 13A, qualifications for appointment of other land registrars. Now we see that a person shall not qualify for appointment as Deputy Chief Land Registrar unless such a person is an advocate of the High Court of Kenya. So you need to be an advocate of the High Court of Kenya. You need to have at least 10 years experience in land administration. You either as an administrator or as a land surveyor, a land economist, or any expert in this field, okay? You need to have expertise of 10 years. A person shall not qualify for appointment as county land registrar, the one that is now appointed at the county level, unless a person is an advocate. So you need to be an advocate of the High Court of Kenya. You also need to be you need to have at least 5 years experience in land administration as either of these people, a land surveyor, a land economist, or an expert in any relevant field. By relevant, we mean in the field of land and administration of land. So we move on. A person will not qualify for appointment as a land registrar unless such a person is an advocate of the High Court of Kenya. So any person who wants to be a land registrar will have to be an advocate of the High Court of Kenya. So lawyers are the ones who are employed in this position as a land registrar, okay? So that's the only, the most important takeaway you need to have. And they must have been involved in any work before that revolves around land, like land administration, land surveying, land economy, or any other field related to land, okay? Okay, so upon appointment, the registrar shall take an oath of office. So there's like an oath. So I told you this is a state office. So it makes sense that everything to do with taking oaths, having integrity, and all those, there's a high threshold for people who are working as public officers as compared to normal ordinary people who work in other areas, okay? Now, upon the commencement of this act, any person holding the position of chief land registrar and land registrars who do not meet the qualifications prescribed in this act shall be redeployed to other positions, okay? and duties within the public service. So if in case people before the act have been holding these positions and before 2012, that is, have been holding these positions as land registrars in all those three levels, and they have not been meeting the requirements of this act, which provides for all these requirements, then they will not remain as land registrars. They are going to be reassigned to other positions within the public service. Okay. So section 14, general powers of land registrars. Now, these land registrars, I was thinking, are dealing with very important things. They are dealing with property. They are dealing with not just any property, but the real deal, the real property here, okay? Property that is immovable, property that appreciates, okay, with time. So it's a big deal to have someone in that responsibility as to make changes to the title, post comments, book it for other things like a compulsory acquisition. They are handling sensitive data regarding ownership of property, and such people will hold powers that will change people's lives, and the powers they hold will also have equal responsibilities. Okay, so they will hold powers, they will also hold responsibilities that or obligations that will be proportionate to the amount of powers they hold. So we have section 14, which talks about powers. The chief land registrar, county land registrars, or any other land registrars may, in addition to the powers conferred on the office of the registrar by this act, require any person to produce any instrument. So there'll be these registrars will have the power to summon the production of any instrument. So they are going to ask for the production of any instrument, certificate, or document, or plan, title deed, lease, anything they will ask. They have the power to ask for it. Okay. All right. So, and you must produce it. So, if a land registrar requires that you produce your title, you can't say, oh, what does he plan to do with it? Or maybe, all these things. You must produce that title. Maybe they want to see and confirm that indeed you are the owner of that title. Maybe they want to clarify uh, any any information they have regarding that land. Okay, so if they have the power to summon for the production of your title deed or your lease or any other document of title, okay, and you have to give it. The second power they have is call upon any person to appear before them and give any information or explanation. So if they call upon you, maybe, or any other interested, you as the proprietor of the land or owner of the land, or any other interested person who has an interest in the said land, they will call on you. Okay, both of you, and hear your cases. They want to confirm whether indeed you have, maybe you have good title over the property, or maybe if there's anything that is missing, or any other process that has been, if the title has been acquired through any undue influence, maybe, or it's a bad title, or maybe the title that's been given to a child who is underage and their name is indicated on the title, at the time they were a baby, so all these things the land registrar can call upon people to explain themselves and give any information. Okay, in regards or in respect to the certificate of title, or the title deed, or the lease. Okay, in case of any license, any instrument of conveyance, they will ask you to provide information or explain yourself. Okay, The third power the registrar is going to have is refuse to proceed with any registration if any instrument, certificate, or other document, plan, information, or explanation required to be produced or given is withheld, or any act required to be performed under this act is not performed. So what you need to know is that the land registrar, yes, he registers. He is in charge of registration of any interest in land, okay? But you also need to know that, yes, in some circumstances, he can refuse to register, okay? He can refuse to register your transfer of property in that land, in your interest in that land. He can refuse to register the lease, he can refuse to register the license, he can do it, okay? He can refuse. He's not obliged to always proceed, so he can refuse to proceed with registration in the given circumstances, okay? In the case that any information he requires, maybe to confirm title, to confirm good title, to confirm that it's okay, laws have been complied with, and he can go ahead to register. If he asks for information and the person refuses to or withholds that information and does not give it, then the registrar by all means has the discretion to refuse to proceed with registration, okay? So in case of non-compliance and uh, in case of non-compliance and in case of withholding of information that the registrar really needs, then he can refuse. Yeah, he can refuse. So if you don't comply with the provisions of this act, the Land Registration Act, maybe if you don't comply with the Land Act, okay, you are going to have a problem registering your property, because the registrar has been given the power to refuse in case of non-compliance, okay? So it makes sense. Another power the land registrar has been accorded with is to cause oaths to be administered or declarations taken, and may require that any proceedings, information, or explanation affecting registration shall be verified on oath or by statutory declaration. So another power he has been granted is to ask. It's like the power of a court to take affirmations or oaths, under statements. For example, if someone does swear that indeed that property has been in the family for generations, and whatever rumors are going on or any doubts regarding the property are not justified in any reason, okay, all this, all the registrar has to do is ask for an oath to be taken. In the case of advocates, for example, who are acting on behalf of their, they can make declarations as to the good titleship of the property, or they can take an oath. So they have been granted these powers I'm talking about are similar to the powers of the court, to summon evidence or documents of title, to summon witnesses or people to give explanation or information, and in this case, to make oaths be taken and declarations, okay? So all these powers are similar to the powers that a court has to summon evidence or materials, summon witnesses or information. You see, all this, just know that the powers according to the land registrar are similar to that of a court, okay? Now, moving on, order that the cost, charges, and expenses as prescribed under this act. Um, So, where it comes to investigations or hearings, the land registrar can investigate title to establish whether it's good or bad, can call on the witnesses to give explanations, can ask for production of titles, can also make oaths, and if anyone declares a statement, they will do so under statutory declarations or under an oath or under what do we call it? under oaths or statutory declaration. And even in so doing, when the registrar is investigating or conducting hearings, if any costs have been incurred while he was doing the following things, all he has to do is simply to do what is to ask the persons, either of the parties, to bear the cost. So you see, the court does that. The court has discretion to allocate the costs of a party or of the proceedings, okay, to any of the parties. Now, the registrar also has this power similar to that of a court to order for the costs and charges arising from incurred by the office from all the investigation that has been done surrounding the title or any hearing, okay, that those costs can be allocated in his own discretion, okay, to the parties, the persons that the registrar may think to be the one who bears the costs. So moving on to subsection 2, in addition to the powers, the chief land registrar will do the following things. Okay, so the chief land registrar, apart from the powers that have been conferred by section 14 of the act, will go ahead and do the following things. He will formulate practice instructions and guidelines for implementation of the land registration policies and strategies. So I think in every act I have read, where in that particular section which allocates powers, it also allocates responsibilities, like I said. So powers are going hand in hand with obligations that the office is required to take further steps in ensuring maybe policies have been set surrounding that matter. Maybe they have created certain guidelines and this. So this is what is happening in this act. It's like a pattern in most of the legislations I have read in Kenya. The pattern is wherever a section allocates powers, it does so in the same breath allocates responsibilities. Now we see here that the chief land registrar, who holds like the is like the boss of land registrars, who holds the highest level, yeah, will do this, will have to create guidelines for implementation of this land registration act and any other policies that this act has given. And we will see that these guidelines will be what we call subsidiary legislation. When we are going to look at all the subsidiary legislations under the land laws of Kenya. We'll have so many, like guidelines, general guidelines on land registration. We'll have compulsory acquisition guidelines. We'll have guidelines on what there are so many. They are called like legal notice number this and this. So we are going to take a look at them once we finish this, okay, and you will see just how interesting this whole thing is, because the act is so broad in perspective. You need subsidiary legislation to break it down into practice, and as we know, we don't really understand the practice of something unless we are doing it. We are on the ground registering title. We have been to the registrar of lands. We know someone there who has experience and can explain to us how things are done in a land registry. We don't know any of those things. We are basically reading the acts, and the acts are broad. You cannot understand what goes on the ground. It only gives you a general overview. In order to understand, you need specific subsidiary legislation or practice policies or guidelines that will at least tell the student, here something, a sale agreement takes this form. Maybe this is what happens when you are conducting survey. These are the guidelines for planning, physical planning, and all these things we need to understand. So moving on, another another responsibility the chief land registrar is going to have is to set standards for the registries, their practice standards in every field of work, and especially a public office. It needs to have a set of standards that will guide the workers there, the employees, the staff, the carrying out of business. The chief land registrar will also supervise the registries. Okay, I told you he's like the big boss of all land registry land registrars, and that power comes with a responsibility to ensure that he's up to date with whatever goes on in any land registry in Kenya, even the county level ones. And in case of any problem, he should be the first person to know. If in case there's non-compliance, there are rumors of corruption in any registry where people are being bribed, where there's undue delays for registration is taking forever, or land searches are taking months to happen. So he is the first person to know. Moving on, he will also prepare and submit an annual report on the state of land registration to the Commission and the Cabinet Secretary. So he will prepare and submit an annual report. So like any state office, they need to be the Article 10 of the Constitution talks about responsibilities. Principles of governance, and one of them is to be accountable. So any office, state office, has to be accountable for what they do, and one of the things they have is an annual report which they will submit, okay, uh, to the commission, the National Land Commission, as well as the Cabinet Secretary, Farida Karuni. Okay, so they are going to do this. They have to do this. And in case the report will also outline the challenges they are facing in any registry, maybe. And so it is imperative that the Chief Land Registrar exercises his responsibility and his powers, and especially the responsibility to supervise and make sure he knows and is up to date with any information on the county level, okay, of all registries in Kenya. He needs to do that. That is the only way he can prepare a good report and have something to report back every year, okay, to the commission and the cabinet secretary. So another thing he has to do is hear and determine appeals from the registries. Okay, I was really wondering if we saw that in section 14 subsection 1, all the registrars have the powers similar to a court. They also conduct hearings just like a court and investigate title to land. So while they're doing those things, if someone is aggrieved by maybe the registrar's refusal to register that property, they are going to appeal to the chief land registrar, okay, maybe who, I don't know where he is, he could be in Nairobi, okay. This is we are going to find out where he is stationed. So the chief land registrar is the person you go to for appeal in case you are aggrieved by the decision of any of the other land registrars in the county level, okay. Another one is approve the format of any instrument which is not in accordance with the prescribed form. So in case that an instrument or a conveyance has been declined because it does not follow the format laid in any of the guidelines or in any of the the guidelines are what normally dictates in minute detail what forms these things should take, like what form a list should take, what form a title should take. In case in case a party's conveyance or instrument has been declined, he is going to be the one to approve the format, okay, and perform such other functions as may be provided under any written act or law. So we see that the powers under section 14 are similar to that of a court: to summon for documents or conveyance, to summon for explanation or people information, to refuse to have discretion to refuse to allocate costs, okay, and to take odds statements under odds. And the chief land registrar has responsibilities to give guidelines and practice, set standards, supervise registries, prepare and submit an annual report to the commission and the cabinet secretary. He will also hear and determine any appeals and also approve any format which is not in compliance with the set standards, and also perform other functions. So in case a question in the exams comes about where you are asked the powers of the land registrar, or you are given a scenario where the land registrar has been refusing to handle, where a client tells you the land registrar has refused to register a certain instrument and comes to you to seek help or a legal opinion or something, you are going to explain this. Yeah, you will cite the section 14, give that he has the power to refuse, and in case any information is withheld, and you argue based on that. Then moving on to subsection 3, the deputy chief land registrar shall be the principal assistant of the chief land registrar in the execution of the functions. So we see that my thought was, while I was going through subsection 2 of section 14, or that why are these responsibilities given to just the chief land registrar, okay, as being the boss, and they a bit like too many to handle for just one office. Then of course later the act will tell us the deputy chief land registrar is the one who will help, and trust me, he will be doing most of these things you see here anyway. Now the county land registrar shall be responsible for administering the registries within the respective county and in the implementation of policies, guidelines and strategies in accordance with this act. So the county land registrar will be responsible for administering the registries within the respective county and in the implementation. So what I take here is that there is more than one land registry in one county, but the county land registrar is the one who will administer all of them, okay? And in the implementation of policies, he will also be responsible. So now my concern has been answered, that the chief land registrar of course will do all these things, they formulate policies, but it is will also supervise. But you see, there's somebody under him that has to report to him about what's going on, and that will be the county land registrar, who will now supervise on behalf of the chief land registrar and report back to him in case of any challenges and other things, and in case of non-compliance with policies. So it is the person below him who will be reporting to him, so he doesn't have to go everywhere in to every land registry. Now moving on, we have the registrar shall not be held personally liable for lawful act discharged by his office under this act in good faith, okay? So this is like an indemnity clause for the registrars, who will not be held personally liable for any lawful acts as long as they are discharged in the course of his employment or his office, and it was in good faith. So moving on, now we'll talk about something called the cadastral map. Trust me when I tell you, I've never seen this. The only map I know is like a geographical map that has these coordinates and shows hills and valleys and all the highest places. So let's see what this is all about. So the cadastral map, the office or authority responsible for the survey of land shall prepare and thereafter maintain a map or a series of maps to be known as the cadastral map for every registration unit. The parcel boundaries on such maps shall be geo-referenced and surveyed to such standards as to ensure compatibility with other documents required under this act or any other law. So the parcel boundaries on such maps will be geo-referenced. I had that georeferencing is simply identification of the coordinates, but I don't know. You can find out more. And surveyed to such standards as to ensure compatibility with other documents. Okay. So a cadastral map, I take it, is that map that shows the boundaries, demarcation of land, like this is parcel number this. They're like all these lines and subdivisions. That's just what I say in my mind. Okay, they will be geo-referenced, okay, and surveyed. So who prepares the cadastral map? That is the surveyor, okay. The office of the surveyor, of the land surveyor, will prepare the cadastral map. Just know that for every registration unit, okay, a registration unit is like a registration area, okay, the area you are coming from. Of course that area has land and the land belongs to certain people, so already there's like a registration unit of that area where one registrar is allocated, and he will maintain the registry, the land register, as well as the what he will also have a cadastral map of that, of the land in that area. So when somebody is coming to register, it makes sense that he will refer to the map, see where the land is, okay, see that it's free from any inhibitions or restrictions and all these things. You need to have a map because we are talking about the face of the earth. It's geography, but it's related to land, okay. Just like you need a map in geography for like everything, it's the same here because we are dealing with land and land is geography. So moving on, we are talking about maps, parcels and boundaries. Now let's move. um, Section 16. Power to alter boundary lines and to prepare new editions. Now, the office or authority responsible for the survey of land may rectify the line or position of any boundary shown on the cadastral map based on an approved subdivision plan, approved combination plan, or any other approved plan necessitating the alteration of the boundary in the prescribed form and in accordance with any law relating to subdivision of land that is for the time being in force. So you can see that again it's the office that prepares the cadastral map that has the power to rectify the line or the boundary of every parcel. I told you, just look at a cadastral map as some paper with lines and boxes drawn. The boxes and the lines represent the boundaries, the boxes represent the parcels of land that have been owned by people, are being owned by people. So every box will have a parcel number, an identifying number that will be also appearing on the title deed of that of the conveyance or on the conveyance instrument. So we have also, it's this person, this office, I will tell you, has the most power because this office of the surveyor can actually rectify that line or that boundary. So if it was like these are the lines of the parcel, he can just move it to this, he can alter it. So this is really a big power, to be honest. So he can also subdivide the parcels where there is an approved subdivision plan to do the same. Approved combination plan, he can combine two boxes. If there is like two boxes, one is here, one is here, they are adjacent, he can simply combine and remove that division line and it will be one parcel, okay. Approved any other necessitating the alteration of the boundary in the prescribed and in accordance with any new law relating to subdivision of land that is for the time being in force. So he is having so much power to alter the boundaries, to merge two parcels of land together, to divide a parcel of land into two parts, okay, or further into other parts. I think where there is like one piece of land now is being sold to multiple owners and every owner has a specific share. So there'll be subdivision, okay, of that property. Are we okay on that? And the land registrar is the person who is the surveyor of land is the authority that is responsible for making those changes on the cadastral map. So moving on, subsection 2, whenever the boundary of a parcel is altered on the cadastral map, the parcel number shall be cancelled and the parcel shall be given a new number. So of course it makes sense. The number that is identifying the parcel is unique to the boundaries, and if they are to change, then the parcel number is also cancelled and a new one is given. If it is subdivided, then a new one, I think, is given. I don't know whether to just the whole parcel or to the subdivisions, I'm not sure. So the office or authority responsible for the survey of land may prepare new editions of the cadastral map or any part thereof, okay, and may omit from the new map any matter that it considers obsolete. So just know that the cadastral map is not a permanent or a static document. It will keep on changing based on what do we call, based on the changes that the surveying land surveyor's office updates on the cadastral map. All the changes we said of subdivision, of combination, all these will be making, all these are proof that the cadastral map is not something that is permanent. It keeps on changing, okay, and the surveyor's office is the one that will be updating the registries in the counties, okay, with all these new editions of the cadastral map. So it's like an ongoing exercise. It's not gonna stop at any one time, okay. Now, subsection 4 of section 16, any rectification to the cadastral map in accordance with this section shall be notified to the registrar by the submission of the rectified cadastral map and all the approvals that necessitated the amendments. Now, we see that they have this power to rectify the cadastral map and boundaries, but this power only comes with approval of showing documents that have been approved, if it's a subdivision, showing the subdivision plan that has been approved, if it's merging of two parcels of land into one, showing the combination approval documents, okay, so approved documents. So the rectification is not just at their own discretion, it is an instruction, okay, based off of the approved documents that are supporting the action, okay, behind it. Now they will also do this, not excluding the registrar. They will notify the registrar, and they will do so by submitting the updated cadastral map and attach the approved documents, that the supporting documents that necessitated that change, okay. Moving on to section 17, approval for further surveys. So under this section, we have that further surveys may be made for any purpose connected with this act, but such surveys shall be used to amend the cadastral map only if it is approved by the office or authority responsible for the survey of land. Now we see here that approval, that further surveys of a piece of land or an area or a parcel can be done, and that survey is only doable after the survey of land has approved it. So yeah, so the office of the land surveyor is a big deal, okay. It's the office that updates the cadastral map. It's the office that creates the map for every registration area in any county in Kenya. It is also the office that makes the changes, subdivisions or combinations, changes the parcel number, okay. It's the office that is on the ground, okay, that engages, that measures parcels of land, that creates the boundaries or identifies the boundaries, okay, through placing the beacon. So it's a very important office in land administration and registration. Without it, just I don't think any registration could take place without the office of the land surveyor, okay? And in case any private party wants to undertake surveys, they have to get approval, okay? But they can do so as long as that survey is not meant to change anything on the cadastral map, because the cadastral map, if a party wants to conduct a survey to or propose a change to the boundaries, if somebody has taken maybe some part of their land, they can only do the survey after they have notified the office of the land surveyor, and they have gotten their approval, okay, to conduct that further survey. So if a party is aggrieved as to the boundaries in his parcel, if it's not accurate, okay, they can just notify the office of the land surveyor and get their approval to conduct further survey. If that approval, of course, is meant to change the cadastral map, okay, but if it's not meant, okay, to change, I don't think you need the approval. If maybe you are planning to sell your piece of land and you want to conduct a survey, you hire the services of a surveyor. I hear that nowadays you can actually hire a private surveyor. You don't have to just rely on the office of the land surveyor to conduct your surveys. You can hire a private surveyor who is going to see the location of the land, maybe determine the value of the land. No, the one who determines the value is the land value. Oh no, it's not the surveyor you can hire. I think it's the valuer. You can hire the services of a valuer, maybe. I don't know. I'll just have to check it, because there have been new changes to the land administration in Kenya, and they're all contained in the subsidiary legislation. So we will take a further look and know more once we get there. Let's not jump the rope, okay? So moving on, yeah, this section will not preclude the registrar from keeping in the registry records of cadastral information and maps approved by the office or authority responsible for survey. So the registrar will keep the historical records of cadastral information, okay? And this, I think, will help with historical searches. If a party wants to conduct a historical search, they will get the information as to any alterations on the parcels and everything. So information to the registrar is key. He is the custodian of any information related to land and land administration, and that includes the cadastral maps, okay? So he can keep the records of any alterations. He can keep the old cadastral maps, okay? Yeah, he can do so under the approval of the land surveyor. So we move on. There are so many players here in land registration, and they are all doing this very important work, and they are custodians of very important information related to land. Now let's move on. The office or authority responsible for the survey of land shall submit to the commission a copy of the cadastral maps, okay, relating to public land, and commission shall be a depository of the maps. So while we studied the Land Act, we found that anything related to disposition of interest in public land, selling of public land, leasing of public land, conversion of public land, the custodian compulsory acquisition, where the government acquires private land and to make it public land, the boss, the agent on behalf of the government, the person to go to is the National Land Commission. Now, where the office of the land surveyor is dealing or is surveying public land and has the cadastral maps, they will not submit the same to the registrars. Okay, they will submit to the National Land Commission, who will be a custodian of those maps. Okay, now section 18, boundaries. We are talking about boundaries except where in accordance with section 20. Okay, it is noted in the register that the boundaries of a parcel have been fixed. The cadastral map and any filed plan shall be deemed to indicate the approximate boundaries and the approximate situation only of the parcel. Okay. So I told you the cadastral map is the one on which changes to boundaries are being made, merging parcels into one, subdividing. So the register, it is noted in the register that the boundaries are not fixed. The cadastral map will be used to indicate any changes to to the boundaries. Okay. So your boundaries, the boundaries to your parcel of land will be uh, proved by the cadastral map. What the cadastral map is showing as where the boundaries of your a particular parcel end or begin, that is what will be taken by the registrar. Okay. The exception is section 20. We are going to look at it where boundaries are fixed and cannot be changed. We will see in which situations a parcel of land and its boundaries cannot be rectified or changed by the surveyor. Okay, by the office of the land surveyor. Okay. So the court shall not entertain any action or other proceedings relating to a dispute as to the boundaries of registered land unless the boundaries have been determined in accordance with this section. Okay. So the court will not hear cases related to dispute of over boundaries, okay, of a registered land. So it makes sense that the registrar hears hearings also in his own office before, and then the chief land registrar hears the appeals related to any decision made by the subordinate registrars. I think this is because the court cannot be given cases every time to hear boundaries. Okay, but I'm going to find out if the High Court or if the Land and Environment Court has received any cases related to boundaries. Then I will update. Okay, let me just note it down. I will hear and see. I will just look it up if the Land and Environment Court has had any cases. Then I will let you know. Okay, I think the court is attempting to do what? To unburden itself and give the land registrars this discretion or jurisdiction or power to hear and determine cases related to disputes over boundaries. Okay. Okay. Now, it is noted in the register that the boundaries have not been fixed. The registrar in any proceedings concerning the parcel will receive such evidence as to its boundaries and situation. So it is the registrar who deals with any disputes related to boundaries. Okay. and will summon evidence and the parties, okay, like we said, exercise its powers under section 14, provided that where all the boundaries are defined under section section 19.3, the determination of the position of any uncertain boundary shall be done as stipulated in the Survey Act Cap 299. So we have another legislation that talks about survey. It's the Survey Act. The Survey Act Cap 299, Laws of Kenya, okay? This one is the act. This is the act that will have the final say in relation to the placement of boundaries that are in doubt, okay? So the Survey Act is the final answer. All right. Now, section 19 is fixed boundaries. We say this, there are times when the boundaries cannot be altered on the cadastral map because they are fixed. Now, that is that situation, okay? It is one such situation we have. So, fixed boundaries. If the registrar considers it desirable to indicate on a filed plan approved by the office or authority responsible for the survey of land, or otherwise to define in the register the precise position of the boundaries of a parcel or any parts thereof, or if an interested person has made an application to the registrar shall give notice to the owners and occupiers of the land adjoining the boundaries in question of the intention to ascertain and fix the boundaries. So so any person, interested person who has uh, who wants to like whose boundary is being affected, or maybe who has a boundary in dispute, maybe with the neighboring person, they will apply to the registrar, okay, uh, who will give notice to the owners of the land, okay, adjoining the boundaries in question of the intention to ascertain and fix the boundaries. So let me just say this, that where boundaries are in dispute, you don't go to the Land and Environment Court, you go make your complaint to the registrar in your area, who is going to notify the owners or occupiers of the adjacent land with whom you have a conflict over the boundaries, and they will come, okay? So I think this section 19 gives the registrar of a registration area the power to ascertain and fix boundaries, all right? Where this power was previously done, or was like in the in the powers of the surveyor, the registrar also has this power, okay, where he considers it desirable to indicate on a filed plan approved by the office or authority responsible. So he will do that with the approval of the surveyor, the office of the land surveyor. He will define in the register the precise position of the boundaries of a parcel, okay, where an interested person has given a complaint or applied to the registrar, and the registrar calls on the owners or the occupiers of the land in dispute over the boundaries, and they will come, and then the boundaries will be ascertained and the registrar will note in the register, okay, with the approval of the land surveyor. Yeah, so okay, so just that is what happens. The registrar can also ask for a survey to be done for the purpose of ascertaining or uh, um, of what, of determining boundaries in a question or a hearing about disputes over boundaries, okay, between neighbors. So they are going to, the registrar will hear the parties, the interested party, as well as the owners of that land, and he will give them an equal opportunity to be heard, okay, and will also make uh, will ask the office of the surveyor to make a survey, okay, a fresh survey, and determine the precise position of the boundaries, okay. He will file a plan containing the necessary information received from the parties, okay, and make a note in the register that the boundaries have been fixed and that the plan shall be deemed to accurately define the boundaries. So before we said that what is used to identify or determine the boundaries of a parcel of land is the cadastral map, okay, that is prepared by the office of the land surveyor. But again, we see that the registrar under section 19 also can have the power to make changes to the boundaries after he hears the parties and he notes down their information, and after he has caused a fresh survey to be done. So he will indicate in his plan, okay, he will file a plan which will contain the necessary changes that have been obtained from the survey, and will note that the boundaries have been fixed, okay, and the plan will now be used to in future to refer or define the boundaries of that parcel, okay. So where the dimensions and boundaries of a parcel are defined by reference to a plan verified by the office or authority responsible for the survey of land, a note shall be made in the register and the parcel shall be deemed to have had its boundaries fixed under this section. So the cadastral map is the original go-to when determining the boundaries. The other, except where the registrar has caused a fresh survey to be done, and with the approval of the land surveyor has filed a plan determining the boundaries now as they have been determined, okay, in the register, then that plan is the one that's going to be used in future to determine the boundaries of that parcel, okay. Now, section 20, maintenance of boundaries. Every proprietor of land shall maintain in good order the fences, hedges, stones, pillars, beacons, walls, and other features that demarcate the boundaries pursuant to the requirements of any written law. So, every owner of land shall maintain the fences, the hedges, the stones, the pillars, the beacons, the walls, and other features that demarcate the boundaries. It's very important that Okay, the boundaries do not exist just on the cadastral map. It's important that if somebody goes to the ground, the beacons that are separating, okay, or the fence or whatever it is, the wall that is showing the parcel boundaries is there and has been maintained, so that if a person is carrying out a survey, it's shown that on the ground, okay, how it looks like. So the person who is responsible for maintaining the beacons that have been put by the Office of the Land Surveyor, he is the one who is responsible. The owner of the land is responsible to maintain those beacons and ensure they are not plucked out. And I think it's an offense to pluck out those beacons. Okay, I think I remember reading somewhere it's an punishable offense to pluck out the beacons put by the Office of the Land Surveyor. Okay. If you constructed a fence or a hedge or some walls, okay, that show your land, okay, you must maintain them as the owner of the land. That's your responsibility, okay? Plus the beacons, you have to protect them. Now, the registrar may, in writing, order the demarcation within a specified time of any boundary mark, and any person who fails to comply with such an order commits an offense and is liable on conviction to a fine not exceeding 200,000 shillings. Yeah. So the registrar can order the demarcation within a specified time of any boundary mark. Now, boundary mark, we said, are those fences, walls, beacons, okay? And any person who fails to comply with that order to put like a fence or beacon, is liable, commits an offense and is liable to a fine. 200 shillings, yeah, of up to 200. So subsection 3, the registrar may in writing order which of adjoining proprietors shall be responsible for the care and maintenance of any feature demarcating a common boundary. So where there's a common boundary, the registrar can order any of the two people to do the following: to maintain the beacons or the fence or whatever, okay? And that person should not let that responsibility go unfulfilled, because if it is destroyed or removed, it's an offense. Yeah, this is, I think, where I read it, and is liable on conviction to a fine not exceeding. So you can even be fined up to 200,000 shillings for removing those things, for removing the boundary mark, the, what do you call it, the fence or the beacons, okay, for letting it be destroyed. And I think this is very important, okay, because as I said, whatever is on the map should be reflected on the ground, okay, and you can't let the ground look anything different. And I think that is why they have these very hefty fines put around that, because it will really not be okay to do what? To let the boundaries become destroyed, yeah, so that people are now confused as to which parcel of land begins where and which one ends where, okay? So moving on, section 21, interference with boundaries, with boundary features, okay? Any person who defaces, removes, injures, or otherwise impairs a boundary feature or any part of it, unless authorized to do so by the registrar, commits an offense and is liable on conviction to imprisonment for a term not exceeding 2 years, or to a fine not exceeding 200,000 shillings, or to both. So I know one person who went, I think, to remove either the beacons or the fencing, okay, to destroy it on a property, and they were fined 200,000 shillings. Yeah, they are fined, and they were lucky they were not put in prison. Yeah, because it's like a serious offense. Any person convicted of an offense under subsection 1, whether or not any penalty is imposed upon the person, is liable to pay the cost of restoring the boundary feature. So if you pay a fine and then you have to restore the feature, if it's a fence, if it's beacons you have destroyed, okay. Okay. So any person convicted, you must pay the cost of restoring the feature. Okay. And if they don't, the cost is recoverable from the person who's responsible of maintaining it. Okay. Now section 22, combinations and subdivisions. We say that in the cadastral map, the office of the land survey can combine two parcels of land into one, or can actually do what? Can divide, okay, using supporting documents which are approved combination plans or approved subdivision plans. Now, subject to authentication of the cadastral map, if contiguous, what is this? Contiguous parcels are owned by the same proprietor and are subject in all aspects to the same rights and obligations. The registrar, on application by the proprietor, may combine these parcels by closing the registers relating to them and opening a new register or registrars in respect of the parcel or parcels resulting from the combination. Let me find out what this word means. So let me see how it's pronounced.
Contiguous.
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 Contiguous. Okay, contiguous. Now it means sharing a common border or touching, okay? Next or together in sequence. So this is the sharing of the same border, contiguous. All right, let's move back. Now, in the case of contiguous pieces of land belonging to the same owner, instead of that boundary differentiating them, the registrar can actually remove it. Mhm. The registrar, on application by the owner of those pieces of land, may combine these parcels by closing the registers relating to them as being separate and opening one which will actually relate to just one combined piece of land. Okay, so the owner applies to the registrar if there are two pieces of land which are contiguous, okay, contiguous to one another, like they share a common boundary but they belong to the same person with the same rights and obligations. So the boundary can be removed and a new register can be opened related to that land, which will be talking about that one parcel of land. Now, subsection 2, upon the application of a proprietor of a parcel for the division of that parcel into two or more parcels and authentication of the cadastral map, okay. The registrar shall effect the division by closing the register relating to the one parcel and opening new registers in respect of the new parcels resulting from the division, and recording in the new registers all subsisting entries appearing in the closed register. Okay. Provided that nothing shall be done in this act that would be inconsistent with the provisions of this act or any other written law. Okay, so just know that under section 22 you can divide a piece of land as the owner and apply to the registrar to close the previous register of land and open a new ones relating to the divisions. If you are one owner of two pieces of land that are adjacent, you can ask the registrar and apply to have the boundary removed, so it's like one big piece of land. That's all that is saying, and all this is must be authenticated by the appropriate cadastral map showing that boundary or parcel. Okay. um, so the registrar has even more powers than I thought, okay, previously. They have the power to make changes to the boundaries, just like the land surveyor, okay? Yeah, so the registrar has some pretty big powers up his sleeve, okay? Now moving on, section 23, reparcellation. I don't know what this is. Let's just look up this word. So reparcellation means the change of common boundaries of two or more adjoining parcels. Okay, let me just a minute. I'll get back. Okay. I'll be right back. How to pause this thing? Let me just end. I'll be right back for